So I'll be talking about civil TROs and injunctions, but you do need to file a complaint. You can't get a TRO or an injunction or any of that sort of relief without first getting a complaint and a case number. And then usually people try to get a TRO, a temporary restraining order, at, at the last minute because it's a sudden immediate request. So you have to at least give 24 hours notice to the party on the other side that you're going to go in for a TRO. Now, if you've just filed a complaint, the party on the other side's not going to have an attorney. So you would give your ex parte notice by fax, some sort of written ex parte notice to the agent for service of process. So that's what you do if you're just filing a claim, just getting the complaint started. So when you file your TRO papers, that ex parte notice has to be in there. If you don't have that in your TRO papers, even if you could have the greatest legal arguments in the world, but if the judge doesn't see that you gave the other side notice, he's not even going to bother reading the papers, especially if the other side doesn't show up. Also, you need to have a proposed order for the court to sign. If the judge does sign your TRO, specifying what sort of relief you're looking for. Yeah, like I said, you could file for an ex parte TRO during any time of the case. Like I said, when I used to do those foreclosures, you did everything at once. You'd go in there, file, we'd get in there 8 o'clock in the morning, file that complaint, go in the ex parte line, file the ex parte papers, and just walk up straight to the department. But you could file for a TRO during any time of the case based on the situation. Then what you would do afterwards, if the judge granted the TRO, it's only temporary, right? What the next step would be going for a preliminary injunction. So that would kind of convert your TRO to this, which would keep the other side from doing what you don't want them to do during the whole case. But usually to get a PI or a TRO, what you have to really show is there's irreparable harm. So you're talking about a situation where there's wastage of assets or a foreclosure sale pending. The irreparable harm is very obvious. You're talking about maybe intellectual property case where the other side stole some coding and all that, and they're starting to distribute it to other sources and make money off it. That's irreparable harm for you there as well. Another thing you have to show to be granted the PI, to be granted the preliminary injunction, especially, is to show a likelihood of success on the merits. So, there are different types of TROs and PIs people can obtain, like I talked about, maybe it's stopping foreclosure sales, domestic violence, which I'm not really covering, but obviously we know that's a big one. Intellectual property, wastage of assets. Some important points of law that I think it's kind of not just in California, but in many other states about TROs and preliminary injunctions is that the plaintiff or the moving party, again, must show irreparable injury or interim harm that it will suffer if an injunction is not issued pending an adjudication of the merits. And in making this determination about an injunction, the court, again, is going to consider the likelihood of the moving party's success on the merits, the irreparable harm if the relief is not granted, and also balancing the hardships. So if the moving party is moving for a PI, but it's actually the other side that may endure more hardship and harm, maybe the judge doesn't grant the PI. So just a little bit more on TROs. It's essentially an emergency court order you get to force the defendant from not taking a specified action. And it's only going to be granted ex parte when you can show, again, you need this emergency relief because you're facing irreparable or immediate harm or danger. And the harm, again, outweighs the harm the opposing party would face as well. And again, a TRO is only granted if you can show that you have the probability of winning the case. And you have to present evidence satisfying these factors like irreparable harm and obviously the ex parte notice. When the TRO is granted, a judge will normally issue an order to show cause, scheduling a follow-up hearing for a preliminary injunction, and that's when the moving party has to provide a lot more evidence, maybe post a bond, because it's a lot harder to win a preliminary injunction because now the judge is essentially going to give the plaintiff relief even before a trial. So, it in some sense it kind of goes against due process, but that's why it's really hard in a lot of instances to win a preliminary injunction. That's all for my discussion on TROs and preliminary injunctions.